Here. Okay, that's great because we have such a full room. So good afternoon, everybody. I'm really thrilled to see so many folks here today, faculty, students, alumni, guests. It's really wonderful that you're able to join us for this symposium, and especially to see such a strong turnout for law review and for this particular event. So our fantastic Albany Law Review has once again organized a very timely and compelling symposium tackling what we know is a very complex but also highly timely issue. So as we all know and are really witnessing, the relationship between federal and state authority and immigration matters has been a subject of very intense debate and litigation for decades, perhaps even more so, never more so than right now. So we are certainly at an acute moment to be examining these relationships, given the conversations that are taking on extra resonance and extra urgency on really a daily basis. So this symposium, From Arizona versus United States to Now, the Status of Immigration Federalism, really promises to delve into the critical legal and policy questions that have arisen in the years since that decision was issued. The issues at stake are profound. They touch upon fundamental principles of federalism, due process, and the rights of individuals, and really the very fabric of our communities and our understanding of our democracy. I want to commend the editors and staff of the Albany Law Review for their incredibly hard work and their dedication that they put into bringing together this really distinguished panel of experts is a phenomenal group. I want to say a special welcome to our guests on the panel, Professor Jennifer Chacon, who's online from Stanford University, Professor Rick Sue, who's also online from the University of North Carolina, Professor Monica Versani, who's here from the City University of New York, and Professor Michael Wishney from Yale University. Welcome each of you to Albany Law School, whether it's in person or virtual. We're very pleased to have you here. I'm very grateful that you accepted the invitation. And they are joined by our very own Professor Ava Ayers here, and a special thank you to Professor Lauren DeRosier, who is moderating the panel today. All of the commitment you've shown to kind of fostering thoughtful dialogue on these critical issues through the work that led into today and the conversations that will happen today are truly appreciated. I'm really proud here at Albany Law School, and I should have said to start with, I'm Cinnamon Carlarn, the very proud president and dean of Albany Law School. I'm very proud here that we're able to create space for the conversations that are going to be had today, and very grateful to our incredibly hardworking journal students for doing so. Now, really more than ever, institutions of higher education, but of course in particular legal education, provide a critical space for engaged and informed conversations and debate on some of the most challenging questions of our time, and today is really a testament to that. I'm really sorry that after this I actually have to step out for a Board of Trustees meeting, but I'm hoping I can come back later to be part of the conversation. Now, before I turn it over, I want to say a special thank you to Alexis Newman, who's the executive editor for Symposium. She's one of our fantastic student leaders, and I know how much time and work and energy and thought you've put into this. And then now I have the absolute pleasure of introducing the editor-in-chief of Albany Law School. Oh, you can be the editor-in-chief of the school too. Albany Law Review, Sarah Madani, who has been a fantastic leader. And she's going to come up now and share a little bit more, but I want to say a special thank you to Sarah and the entire Law Review team, and welcome up.
Thank you, Dean Carlarn. Good afternoon, and thank you so much for joining us. My name is Sarah Midani, and I'm the editor-in-chief of the Albany Law Review, Volume 88. On behalf of the Law Review, I'm thrilled to welcome you to our annual flagship symposium. And as Dean Carlarn said, this afternoon's program is called From Arizona, the United States to Now, the Status of Immigration Federalism. We're delighted to welcome a distinguished group of panelists today, both in person and on Zoom, to explore the rapidly changing landscape of immigration regulation in the United States. We look forward to bringing you a compelling, timely, and thought-provoking discussion this afternoon. Immigration issues are front and center in today's media and politics, and as the US adjusts to a new presidential administration, Volume 88 is in a truly unique place to host this dialogue this year. Today's event seeks to shed some light on an important question. What role, if any, should the states play in regulating immigration? Before we introduce our moderator and panelists, I want to recognize Albany Law Review's executive editor for Symposium, Alexis Newman. As Dean Carlarn said, Alexis has put in so much of her time to this symposium. She was appointed to her position last March, and over the better part of a year, she has spent countless hours developing the symposium that will unfold here this afternoon. Her passion for the field of immigration law was evident every step of the way, and it's been a true privilege and pleasure to work with Alexis on bringing this symposium to life. It is now my pleasure to introduce Alexis Newman.
Hello, everyone. I'm Alexis Newman, the executive editor for Symposium for Albany Law Review, Volume 88. Welcome to our program today. I want to thank the numerous people that have contributed to this event today, including our esteemed panelists, our wonderful moderator, Lauren DeRosier, the Albany Law Review editor-in-chief, Sarah Madani, Lisa Ravage, John Collins, and the admin services team, IT, Lauren Manu, and Julie Pierce. The federal government has held nearly exclusive authority to determine who may enter and live in the United States for over a century. Yet recently, states have started to test the boundaries of their power. With a growing number of state-level immigration laws, the future of who controls immigration and the methods that may be used to do so is less stable than ever before. Many have assumed that the question of state immigration enforcement was settled law. In 2010, Arizona enacted Senate Bill 1070, effectively allowing state law enforcement to police federal immigration law. 2 years later, the Supreme Court confirmed the federal government's authority over immigration control, holding that the key provisions of the bill were preempted by the federal government's broad authority over immigration. Yet, state immigration regulation and enforcement has picked up since then. Over the past few years, states have tested the limits of federal preemption and made ventures into immigration enforcement, some of which oppose federal authority. For example, Texas's Operation Lone Star placed razor wire along the U.S.-Mexico border and buoys in the Rio Grande to prevent people from crossing. Other examples include Texas's Senate Bill 4 and Florida's Senate Bill 1718, both which increased state law enforcement's power to engage in immigration enforcement. In the past several weeks, the new administration has issued several executive orders that may push state and local law enforcement to comply with federal immigration policies. Additionally, in the recently passed Lake and Riley Act, Congress granted additional powers to state attorneys general, encouraging states to challenge federal decisions whether to detain people under immigration laws and giving them a larger role in immigration enforcement. Today, our panelists will dive into these issues, discussing everything from the developments of the past few weeks to the way these issues implicate long-standing tensions. And to moderate this discussion, I will introduce our very own Lauren DeRosier. Lauren DeRosier is a visiting assistant professor and the director of the Immigration Law Clinic here at Albany Law School, and we are very lucky to have her today moderating.
Hi, everyone. I'm going to make this very brief because we have so much to get to, and I really want to talk to all of our panelists today. I'm Lauren. I am going to introduce our panelists very briefly, and then I will hand it off to Mike Wishney to get us started. At the end, we're going to have a moderated discussion, and then we'll open the floor for some audience questions. So our first panelist today is going to be Mike Wishney. Mike Wishney is the William O. Douglas Clinical Professor of Law at Yale Law School, where he has also served as counselor to the Dean and Deputy Dean for Experiential Education. We will then pass the mic to Monica Varsani, who has a very, very long and illustrious resume, which I am going to abbreviate. She is the Associate Provost and Dean at the CUNY Graduate Center. She is on the Geography Doctoral Faculty and International Migration Studies Master's Faculty at the CUNY Graduate Center. She is the full professor of political science at John Jay College, CUNY. We will also, I may have messed up that order, sorry. We will also have Jennifer Chacon, who is the Bruce Tyson Mitchell Professor of Law at Stanford Law School, joining us, as well as Rick Sue, who is the Professor of Law at the University of North Carolina School of Law. And we will be concluding today with our own Professor Ava Ayers, who is the Associate Professor of Law at Albany Law School and previous Director of the Government Law Center. Please welcome our panelists. And Professor Wishny, I'm going to turn this over to you. If you want to come up, you're welcome to, or you're welcome to sit down.
Is it okay if we stay here? Sounds like you can hear me. Yeah, okay. I'm a trial lawyer, so I'm going to put on my clock. Well, thank you so much for having me here today, especially to Alexis and everyone at the Journal who did such terrific work in pulling this together. Ray Brescia, who teaches here, is one of my closest friends, but somehow he's never bothered to invite me here before. So I'm really grateful that I finally got the golden ticket to Albany Law School. So thank you for that. What a prescient choice you guys made months ago, a topic that is front and center in the headlines, in the courts, in Congress, in the states, and a set of issues that I think are going to engage us in intense conversations and debates in this country for the foreseeable future. The role of the federal government and state and local governments in immigration policymaking as well as enforcement. So I know the title is From Arizona to the Present, but I'm going to start, since I'm going first, I'm going to start a little bit earlier just to set a tiny foundation, but very rapidly. So for the first 100 years of the United States, the primary regulators of immigration were cities and states. Almost all the meaningful laws and policies and statutes that governed who could enter the United States were made by cities and states. It was the Port of Philadelphia and the Port of New York and the Port of San Francisco. So actually, for about 100 years, we had almost no federal immigration regulation. One theory is that the debate over slavery precluded Congress from regulating the movement of people, and so there could be no agreement in Congress, and so there were almost no federal immigration laws for the first 100 years. Okay. After the Civil War, Congress begins to enter the space, and in the late 19th century enacts some of the first exclusion laws, like Chinese exclusion, and then deportation laws to take people out of the country, not just stop those from entering at the border. The 20th century reflects a period where Congress increasingly regulates in greater and greater detail and kind of gives us the modern immigration system that we live in now through major acts of Congress in 1924, 52, 65, 86, 96. So the story of the 20th century is largely one of Congress stepping into this space and displacing state and local regulation. So by late in the 20th century, there's almost no formal regulation of immigration possible at the state and local level. But that doesn't mean that there isn't inevitably friction between the federal government and state and local governments. And that's because the development of the modern administrative state, both at the federal level and state and local levels, means that inevitably there is going to be some interaction. States say, well, it's a traditional power of the states to run schools and to run police departments and public welfare systems. And yet the federal government begins to see those systems as having potential utility in federal immigration enforcement. And so there starts to be friction in areas where there is a traditional state or local role, but also a federal government interest in deploying state and local assets in the service of federal immigration goals. So there's some friction. But I think that it's true that, as Alexis said, there was a sort of stability that emerges where there's no question, but that the federal government is preeminent, is supreme. And so if the federal government legislates an immigration statute, that is the law of the land. There's no real debate about that. And that can and often does displace state or local power. But there remain many areas where the states are necessarily acting. And sometimes there is this friction with the federal government. Since the September 11th terrorist attacks, I think that friction has really intensified, and we're seeing it kind of supercharged in the first few weeks of the current administration. After 9/11, the federal government became much more assertive in seeking to not just occasionally invite local police to join a joint task force or something like that, but to actually co-opt state and local police in the service of immigration enforcement goals. And so through, and I'm going to be a little technical here, but through measures that had been on the books for some time but not used. After 9/11, the federal government executed the first 287G agreements, which allow local police to exercise federal immigration authorities if they're trained and supervised and they have an agreement. We hadn't had any of those. They became somewhat widespread. The federal government took the position that state and local police had the inherent authority to engage in immigration enforcement even without a 287G agreement. They began to populate federal law enforcement databases with civil immigration records so as to enlist local police and others. So in many ways, there were these efforts by the federal government to integrate or even co-opt state and local law enforcement into immigration enforcement. That was a big change. And of course, some states went beyond that, like Arizona in SB 1070, and sought to assert an independent ability to engage in immigration policymaking as well as immigration enforcement. The Supreme Court checked some of the worst excesses of that in the Arizona decision, but it didn't completely rule out the possibility that there might be a role for states. Well, so here we are in 2025, and at some level, all bets are off. The administration is pushing far beyond, in my view, where even the Bush administration went after 9/11, not content to settle for using police under 287G agreements where the department agrees and is trained and is supervised by federal immigration authorities. This administration, for instance, has invoked a provision never before invoked, declaring that there is a mass influx of immigrants at borders and that this mass influx is impacting all 50 states, such that local police can engage in immigration enforcement even without a 287G agreement. The administration, of course, is going beyond willing police departments to begin deploying military assets to the border. And Operation Lone Star was mentioned. That is a Texas governor's decision to send Texas National Guard to the border on state orders under National Guard rules, not even subject to federal control, to police the border. And now already in the first 2 weeks, we have cities and states suing the federal government, saying you're encroaching on our authority. You have the federal government suing local jurisdictions just this week, filing suit against Illinois and the city of Chicago, saying your local policies interfere with immigration enforcement and we want them invalidated. And once again, it looks like the courts will referee a fair amount of these boundary disputes as to where the limits of federal power or state and local reserved authorities lie. So I want to mention one kind of new site of contestation. Battles over police, over schools, over public benefits go back over the last 20 years. But I wanted to just take a couple minutes to identify what I think is a new site that is likely to engender all kinds of policy and legal conflicts. And that is actually the National Guard, the use of the National Guard. The National Guard, some of you may know, anyone here in the Guard? Just out of curiosity, anyone here in the Guard? Ever been in the Guard? Okay. So the National Guard is a genuinely hybrid force that is made up of people who serve a weekend a month and 2 weeks a year. And they are sometimes state employees doing lots of state jobs. A lot of governors use the Guard now as a sort of supplemental state workforce to deal with the hurricanes and blizzards and flooding, to deal with COVID. I drove up here through Massachusetts. The governor of Massachusetts has used the Guard to drive school buses. They're sort of a supplemental state workforce. And at times, they are state employees paid by the state under the control of the governor. At other times, they are mobilized into federal service under what are called Title X orders. And then they are paid by the federal government, and they are subject to the president as commander-in-chief. They are basically just like any other member of the federal armed forces. And then there's a middle status, Title 32 orders, where National Guard are paid by the feds and subject to operational control by the feds, but the commander-in-chief remains the governor, not the president, this middle ground of Title 32 orders. So why am I telling you all of this? Because the president has expressed a lot of interest in deploying the military in the service of immigration enforcement. A statute called the Posse Comitatus Act generally prohibits the federal armed forces from domestic law enforcement. However, the National Guard on state orders, so like Operation Lone Star, or on Title 32 orders, this hybrid status, are exempt from Posse Comitatus and can engage in domestic law enforcement. And the current administration is looking for resources to supercharge immigration enforcement, and they're not sure they're going to have enough police in willing states. And so they're looking at the hundreds of thousands of National Guard members around the country, and to avoid Posse Comitatus, looking to engage them on state orders or Title 32 orders. This is putting governors into conflict with the federal government already. And that middle status, Title 32, which governors like because the federal government pays for it, but the governor is still in control. They are negotiating whether National Guard will do immigration enforcement or not. And the National Guard is not the state agency that is usually at the center of policy and legal debates. At least in Connecticut, I know in a number of states, it's a little bit of a sleepy state agency, vital functioning, of course, but not the center of a lot of state policy debates. But I think that's changing. National Guard members, some of them are very resistant to the idea of doing immigration enforcement. Others are gung-ho for it. But it is now pitting the federal and state governments in opposition. And in fact, the concern goes beyond merely federal pressure on blue states to mobilize their guard for immigration enforcement. But the question is arising, what happens if the Texas National Guard enters Colorado, or the Florida National Guard comes to New York, and literally armed military personnel over the objection of the current governor from a foreign state enter the state because the governor of New York doesn't agree to deploy her National Guard, for instance, in service of immigration enforcement. That issue has never been litigated. There's lots of good reasons to think that's unlawful, but we've never been in a world where one state's National Guard invaded another state over the objection of the governor. Plenty of times, New York Guard goes to Louisiana to help with a hurricane, they're welcomed in. We're not talking about that at all, but that's a very active scenario. And governors are struggling to figure out what they might do in that situation. Again, I think there's good reason to conclude it's unlawful, but there's not a line of Supreme Court cases that have ever had to consider that question before. My time is up, so I'll end just by noting that I actually think that Guard is likely to be a site not only of debates about immigration and federalism, but given the ban on transgender persons serving in the military, there's going to be pressure on governors to expel trans members of the National Guard. And there's a nascent set of efforts to unionize National Guard, beginning with Operation Lone Star soldiers in Texas, of all places, that is leading to a kind of a bit of a pushback collectively from within some of these places. And the unionization is going to also make the Guard a perhaps unexpected source of civil rights struggles now. So I will leave it at that. Thank you.
Good afternoon, everyone. I think I'm next, and you should never try to follow Professor Wishney. So I feel rather humbled here, sandwiched between Professor Wishney on the one hand and then Professor Varsani on the other. It's a tough act to both follow and proceed. I want to give my thanks to the Albany Law Review students who have worked so hard to put this event together, to Alexis Newman for herding cats and getting us all here, and making sure that we knew what we were supposed to do. And thanks to all of my esteemed co-panelists and to the moderator for their time today. I couldn't agree more that this is a hugely timely topic. I'm realizing I didn't start my clock. You can see I'm not a trial lawyer, but I'm starting it now. And I will try to stay true to time. The organizers asked me to cover 4 topics, and I'm going to use their questions as basically the organizing device for my remarks. And there's probably going to be overlap between much of what I say and the things that other people will say today, but I think these overlaps will focus on different aspects of questions and different levels of the question, and hopefully will be generative to the conversation to come. So the first question I was asked to address is, what is immigration federalism, which we could spend a lot of time on, and which we presumably will. So I just want to sort of briefly say, and this was evident in the remarks that Professor Wishney just made, as in many areas of law, federal and sub-federal governments divide and share responsibilities for various aspects of law and policy that affect immigrant residents. But we have typically thought that the control of immigration law, that is, who enters, who remains, who is deported or removed, what are the procedures that surround those choices, who's detained pending those procedures, those have really, since the late 19th century, really been firmly planted in the hands of the federal government. And this is one space where we're seeing some conflict and tension today that we'll continue to explore today. On the other hand, and this Rick Su's work really, I think, shows this nicely, and I'm sure he'll talk more about it, there are lots of laws and policies that affect immigrant residents over which states and localities have shared authority with the federal government or total authority unless that authority is displaced. And so there are lots of questions that have long interested me that really implicate immigration federalism. So who gets to enforce immigration laws? What are the federal statutory and constitutional limits on state and local police participation? Can states and localities opt out of cooperating with federal immigration enforcement efforts? And another area we're going to see a lot of conflict and tension in coming months. Do states and localities have standing to challenge federal immigration policy choices, and when and on what terms? An area where Lake and Riley is going to move the goalposts. And how do questions of immigration federalism relate to broader questions of equality and citizenship? So a lot of this is in flux right now, and it makes this conversation and this symposium topic particularly timely. The second question that I was asked was, how do multi-level responses take form in response to federal policies, and how do they affect immigrant residents on the ground? And I think that Professor Vashani is going to talk a lot about the question of how we see the rise of state level immigration related policies. So I will sort of defer that conversation until she makes her remarks. I want to really focus on how people are affected by the overlapping layers of law and policies as they live their lives on the ground in various places. Last year, I, along with Stephen Lee and Susan Gutine, published a book called Legal Phantoms, Executive Action and the Haunting Failures of Immigration Reform. And the title doesn't exactly scream immigration federalism, but the book has a lot to say about how people experience immigration federalism every day and how that experience varies, even in geographically contiguous places. So the book focuses on the period from 2012 through 2022. And to kind of take you back, much less time than Professor Wishney took us back. But in 2012, you might remember the country was experiencing, under President Obama, really expansive immigration enforcement efforts in the interior of the United States. In some ways, the numbers of removals there have been higher than anything that we've seen since, including under President Trump's first term. At the same time, that administration was also announcing a deferred action for childhood arrivals, granting work authorization and a reprieve from removal to some young immigrant residents. And so our book charts the changing federal immigration policies over the years that followed, from the Obama administration's thwarted efforts to expand deferred action for childhood arrivals and add a deferred action program for parents of US citizens and lawful permanent residents, to its scaling down of interior enforcement efforts in favor of tougher border enforcement through President Trump's immigration enforcement efforts, which were more scattershot but more sensational and spectacular in the interior, and which amounted to near total border closures to migrants seeking refuge and asylum protections at our southern border. So we mapped those federal policies, and those federal policies, especially deferred action programs and other programs that gave liminal statuses to migrants during this period, are the backbone of the book. But the texture of the book comes out of how people are experiencing these policies on the ground in local spaces. So in the book, we're interviewing people in two California counties, in Los Angeles County and Orange County. They're both in the state of California, which is a state that had enacted laws increasingly protective of immigrant residents over the course of our period of study. But these counties are very different politically and demographically, and they have different policing realities. And those differences really showed us just how much state and local policy shape the experience of longtime immigrant residents in the US today. So I don't, I'm going to read briefly from the book just to give you a sense of some of what we heard and saw as we were talking to people in researching the book. So several themes recurred in our interviews with Southern California residents in the mid-2010s. First, many residents of both Orange County and Los Angeles County expressed concerns that police would target them or their loved ones for investigative stops based on race. Second, while residents of both counties expressed concerns that the police might give them erroneous tickets or impound their vehicles, residents of Orange County were on balance more likely to be concerned that these stops could lead to arrests and deportation than were residents of Los Angeles County. So suggesting local policies mattered to how people felt their police encounters would or would not endanger them of being placed into immigration proceedings. Third, people we interviewed frequently expressed the view that the passage of California's AB 60, which allowed undocumented residents to access driver's licenses in the state, had made them less fearful and more protected from abusive policing practices. Fourth, no one we interviewed felt that local policies could protect them from the direct actions of federal immigration officers. Finally, and consistent with the findings of other scholars, we found that the fear of deportation was often not the most salient concern that undocumented residents had when interacting with public officials. Concerns about mistreatment and discrimination were more routine. Sanctuary policies, which prohibit the sharing of information about immigration status, seemed to decrease residents' fears that contact with local police would lead to deportation, but these residents still felt vulnerable to local police due to their immigration status. Policies like AB 60 were at least as important, if not more important, than sanctuary policies in providing security for immigrant residents. But even AB 60 protections and other protective state laws did not eliminate residents' perceptions that police unfairly targeted them for enforcement actions, particularly around traffic infractions. And so I read that excerpt just to make clear that states and localities, this sort of brings me to the third question the organizers asked me: what avenues do or should states and localities have to protect their immigrant residents in a time of rising federal enforcement? And that passage shows that states and localities can't, either as a legal matter or as a practical matter, stop the federal government from enforcing immigration law in accordance with federal law. But in the past, at least, these government actors have had a lot of levers that they could use to improve the lives of immigrant residents or make their lives harder and more precarious, including choices around what to criminalize, including choices around business licensing and other licensing choices, including choices around arrest policies, around data collection and record-keeping policies, around the use of electronic surveillance and policing, around how to provide services like healthcare, education, and labor protections, and of course, the policies around the terms of communications with federal immigration enforcement agents beyond whatever is required by federal law. So all of these are spaces where states and localities make different choices, and those choices have very real impacts on how people experience their lives, regardless of what's happening on the higher levels of federal immigration policy. And that brings me to the final question. What can we say, the organizers asked me, about the legal standing of states to use litigation as a tool to challenge and stop federal immigration policy initiatives? So here we can say that we've seen states and localities using litigation as a tool to try to shape a federal immigration policy far more recently over the past couple of decades, and really crystallizing in the last decade. In the Legal Phantoms book that I just referenced, Stephen and Susan and I chronicle the successful effort of states, including Texas, to use a lawsuit to stop the implementation of the federal Deferred Action for Childhood Arrival expansion and the proposed Deferred Action for Parents program. We also saw states successfully using litigation under Trump 1, and again, we're seeing them attempt to use litigation as against the current administration. Under Trump 1, we saw states' efforts to stop Trump's entry ban aimed primarily at Muslims, which forced a narrowing of the program before the Supreme Court ultimately approved it. And more recently, we see challenges to Trump's unconstitutional efforts to selectively strip birthright citizenship. But we really saw a lot of this litigation under Biden, where states, often led by Texas, ground down various executive immigration programs and initiatives, ground them to a halt through their litigation efforts, even as they, as we've just talked about, expanded their own direct immigration enforcement efforts. The Lake and Riley Act, which purports to expand state standing to challenge immigration policy choices, is likely to increase the frequency of state litigation interventions against inclusionary policies enacted at the federal level. But it doesn't provide parallel opportunities for states to challenge problematic federal restrictions on their non-citizen residents. So it's very much a sort of one-way lever about when states can participate in litigation as against federal immigration policies. And that is very much by design. So I think we can expect to see more state interventions, but only in one direction. I think we can anticipate that states who favor more integrationist approaches to immigration, who disfavor some of the Trump administration's immigration policies, will continue to use the courts as an effort to slow down some of these programs. It remains to be seen the extent to which they are deemed to have standing in these various efforts and how successful these efforts will be in light of the current configuration of the U.S. courts. But there will be a lot of action for lawyers and a lot to watch in courts. So I think I'm about at time, and I don't want to go over. So with that, I'll turn it over to, I think Monica is next.
Let's start the slideshow.
Are you sharing the screen?
This one.
Yep. To the Zoom.
Should work if you just go to slideshow.
Yeah, just get the slideshow. It's over, it's tucked in that side of the screen. Yeah, there we go. Great, thank you. Great, thank you. Thank you so much, everybody, for welcoming a social scientist into your midst. So I hope I have something to offer here. It's really such a delight to be on this esteemed panel. What I'm going to be talking about today is a sort of a subset of a paper that my colleague Wayne Cornelius and I just published in the Journal of Ethnic and Migration Studies. Is this working? Let's see. Yeah, there we go. So again, we're going to maybe repeat a little bit, but what is immigration federalism? Starting in the mid-2000s, we see a lot of cities and states jumping into the fray and starting to enact immigration policies or policies that impact immigrants who are living in their communities. Even within states, you see a lot of variation. So you have different cities doing different things, different counties doing different things, and cities within counties doing different things. So this really, with some places being more pro-immigrant, some places being more anti-immigrant. So what you really end up with here is what we've called a multi-layered jurisdictional patchwork of policies across the United States. Now, again, this is a social science paper. So what explains the variation that we're seeing across the country? Early on in sort of the mid-2000s, a lot of folks were arguing that it was really related to what we call the new destinations phenomenon. So the idea that there's migrants moving to different parts of the country where they haven't lived previously, and therefore cities and states kind of reacting to that demographic change and passing policies to deal with it in whatever way they wish to. What we really see more now from, and particularly political scientists have argued this, is that it's much more related to partisanship. So you can have places that have new destinations, but if you have a more democratic leaning polity, then you'll have typically policies that embrace immigrants. And if you have a more Republican leaning policy, then you'll have policies that are more restrictionist. So this paper looks specifically at what are called issue entrepreneurs or politicians who really use immigration as, or another policy area as well, but in this case immigration, to sort of further their careers and push forward certain agendas. So immigration federalism is a useful vehicle for issue entrepreneurs who are interested in kind of hitching their wagons to it. This is not going to be a surprise to anybody in this current moment to hear this. Issue entrepreneurs don't just identify an issue of public concern, so they're not out there saying, oh, there's a lot of people who are really interested in this issue, I'm going to pass a policy or propose a policy. They see something that could get their agenda out there and then hitch their wagon to it and amplify it even larger than it might have been originally. So we really see a situation where state level immigration control laws and ballot propositions issue entrepreneurs will intensify partisanship and intensify cultural anxieties, and in essence, use that to advance their careers, get elected, try to get elected, et cetera. So what we were trying to do in this paper is connect, you know, it's one thing to say, well, there's a place that's partisan and there's a place that has demographic change. Well, what gets us from that to policies being proposed? And what we're arguing is that's these issue entrepreneurs. So I know that the title of the panel was from SB 1070 to the present, but I'm going to take you all the way back to California in 1994. Sort of the granddaddy of immigration federalism policies at the state level was Proposition 187 back in the mid-90s in California. So here we have Pete Wilson, who was the governor of California at the time, who was facing a very, very stiff re-election campaign in the mid-1990s and was very far behind in the polls, and came up with, and I don't know if I can show this or not. Is this possible to, is there a mouse here somewhere? I would love to show this video if I can. It's like a 20-second video.
Sometimes it works.
Yeah,
Sometimes
let's
it doesn't. Let me give it a try. Is this a link to YouTube in your?
Yeah, it is.
Okay, let me come out of.
Maybe it's not
Oh,
going
it doesn't seem to just.
shoot.
Oh, hang on. Let me 1 second. I'm a terrible tech assistant, by the way. I utterly unsuited for this. No, that's okay. Yeah, I don't see the link.
It's not going to
I don't
work.
know how
Okay, that's fine.
Sorry. I'll put it back
So
in a second.
later on, if you're, you know, hanging out and don't know what to do with your time, take a look at, search this video. Oh, it now disappeared too. Oh, wait, there it is. Let's watch it. Okay.
They keep coming. 2 million illegal immigrants in California. The federal government won't stop them at the border, yet requires us to pay billions to take care of them. Governor Pete Wilson sent the National Guard to help the Border Patrol. But that's not all.
For Californians who work hard, pay taxes, and obey the laws, I'm suing to force the federal government to control the border. And I'm working to deny state services to illegal immigrants. Enough is enough.
Governor Pete Wilson.
Okay, this will sound somewhat familiar to the context today, I think. This is very similar to things that we're hearing in today's day and age, and now this is not advancing. Let's see. Oh, wait, let me go down back to here. There we go. Okay. So Pete Wilson was behind in the polls when he launched this Proposition 187 campaign in conjunction with other California citizens. He won the election, and Prop 187 was passed with, I think, 56% of the vote. It was much of it was overturned by the courts later on, but it started a whole era of immigration federalism. And this was in 94, and then we see federal laws being passed in 1996, and so forth. So you really see the origins of this movement in the Proposition 187 moment. Taking us to the present, we've heard a little bit about Greg Abbott so far. We see Texas Governor Greg Abbott being a part of this whole movement, and Operation Lone Star, which really kicked off in 2021. And here's just a list of the various things that were involved in Operation Lone Star, including a lot of appropriations by the state legislature, state troopers and National Guardsmen, which Professor Wishney spoke of, concertina wires strung along the border, et cetera, et cetera. And then, of course, SB 4, which was signed by Abbott in December of 23, which created the state crime of entering and being present in Texas without legal authorization. Again, not something that you would typically associate with state control, okay? Here we have, again, the transportation of migrants from the Texas border to New York City, where I live. And that changed, created a very interesting time in New York City vis-a-vis immigration. And here's the floating border wall with the sort of the razor discs embedded inside of it. Secondly, we have, or third, I should say, we have Governor Ron DeSantis of Florida, who is also an issue entrepreneur, and passed in 23 Senate Bill 1718, which has a whole list. I won't read through them, but you can see a whole list of many things that you will often see in the kinds of bills that have been passed in immigration, state level immigration laws, in which we see repeatedly coming up in today, and we'll continue to keep seeing coming up, okay? So just to conclude, I don't want to take too long. Some of the key takeaways that we have here is that issue entrepreneurs will continue to be important in this field, obviously, making that linkage between partisanship and ethnic and cultural anxieties and the passage of local, state and local immigration policies. The partisan nature of this continues as well. During the Obama administration and the Biden administrations, we see a lot of anti-immigrant laws being passed at the state and local level. And then during the Trump administration, the first one, we saw a lot of sort of more pro-immigrant sanctuary or non-cooperation ordinances being passed. What we do see is some interesting dynamics arising within Trump sympathetic state and local officials who are sort of trying to demonstrate their allegiances with the new Trump administration. So I don't know if any of you have seen this, but just recently, Florida's SB 2B and HB 1B, the Tackling and Reforming Unlawful Migration Policy Act, or Trump Act, was trying to bolster increasing connections between state and local law enforcement and ICE agents and expanding detention capacity. And a lot of people read this as really like poking DeSantis in the eye, because DeSantis obviously has tensions with Trump. So these are local officials who are kind of like pitching their wagon to the Trump enforcement campaign. And then we've seen a lot of continued activism since the election to the present time at the state and local level. So we have more restrictive measures being passed in Arizona, Oklahoma, Tennessee, Idaho, and others. 8 states that passed laws in the last election around non-citizen voting, which empirically is a non-issue. And then integrative measures in a number of cities across the country, as well as in Oregon and other places. So that's it. I'm looking forward to our conversation. Thank you.
Okay, I think, let's see. Can you guys hear and see me? I'm on the screen?
Yes,
Okay,
go.
great. All right, so first of all, thank you for the organizers for inviting me to this event. I am sorry that I'm not there in person. I visited Albany Law School many times, also being a resident of upstate New York before. So regretfully not being able to make it this time and really visit everyone on the faculty and to see all of you in person. So what I want to talk about today is in some ways to examine, right, our traditional understanding of immigration as a national issue and federal responsibility, but not just how the panel is titled, which is how state is influencing it, but I want to make sort of the bold claim that right now states are in a position to actually reverse our traditional understanding between federal and state, and that they're in a strong position here to actually start dictating immigration policy in the near future. And this is not only because in some ways state governments right now hold the linchpin with regard to essentially federal immigration strategy, or more specifically, their ability to commandeer their own local officials to carry out federal immigration enforcement priorities, but also, and I think we're already seeing some examples of this, more and more states actually going at it alone, passing their own state immigration regulations and essentially substituting for the federal government's capabilities and also their authority and power. And I will end with a hot take, if you will, and that is essentially that Lake and Riley is a poison pill, and that not far from now, maybe in 2 years is my prediction, Trump is going to regret signing this. And that'll all fold into what I'm talking about with regard to the setup. Now, just to sort of frame it a little bit, and I'll kind of piggyback off a little bit of the history that Professor Wishney began with. The truth is the states have always played a vital role, if you will, or an important role with regard to the development of immigration policy, right? Certainly we could talk about really immigration laws being regulated at the federal level, really starting in the late 19th century. But the truth is most of the early immigration laws that they passed, and they had to pass them fast because the Supreme Court essentially gave them all the power in one fell swoop, were essentially just copying the state laws that existed at the time. So early laws with regard to, and I'm quoting, lunatics, paupers, convicts, those were all already existing at the local state level, and they just sort of implemented them into federal law in order to maintain them. Even the sort of development administratively of Ellis Island, that was copying Castle Gardens, which New York had already operated beforehand. So this is to say that even from the very beginning, this kind of state influence on federal policy has always been quite live. And certainly once we got into 1986, the employment restriction that you might have heard about in the Decanis decision that was in California, that was essentially copied wholesale in 1986 with now what we have, which is the federal restriction on a sort of check on immigrant employment. As noted before, Proposition 187 and different California laws really fixating the idea of unauthorized immigrants having access to benefits. Yes, that got all, sort of withheld by courts. But once you got into the immigration bill in 1996, essentially, both in the welfare reform bill, but also the immigration reform bill, all these sort of restrictions on benefits were incorporated from what Prop 187 tried to do into federal law. And of course, once you get into SB 1070 and onwards, we're seeing this sort of trend in which in some ways the laboratory, if you will, of various states and of course issue entrepreneurs pushing the immigration issue, then actually starts appearing, right, shaping the debate and appearing as federal law. So in some ways, we're seeing this sort of continuation. But what I want to say is that what we're seeing today is not just in the area of developing policy, but more specifically in the area of enforcement. So not just essentially with regard to laws that states pass that then may influence Congress, but more specifically with the actions and also the laws that states pass that influence in some ways how the executive actually carries out the enforcement function itself. And what I want to say here is that this was relatively new. And this actually didn't start necessarily at the state and local level. It began at the federal level. So essentially, one of the things that happened post 9/11 was, and during the Obama administration, when the numbers started going up primarily, was the federal government became dependent, if you will, reliant, I want to say, on state and local enforcement, right? To be fair, we're focusing on quote unquote criminal aliens. But the idea that essentially through Operation Secured Communities with fingerprint checks and combining different sort of databases, with the idea that someone in an ICE office can sort of send out or fax over a detainer, sort of dramatically expanded the capability that the federal government had to do interior enforcement. And let's be frank, on the cheap. And although that started off as sort of a pilot program and a nice to have, I think what we're seeing is that's increasingly been folded in as a necessary component with regard to what the federal governments do. In other words, when they're making the initiative and strategy, that component is folded into it. That has to be a critical component. As a result, what ends up happening is now the federal government is not only just dependent and reliant on voluntary cooperation, they really want to have a little bit more of a coercive force to it. Now, you might say, if federal government mandates, if the federal government is sort of in charge of immigration enforcement and they're in charge of immigration policy, why don't they just mandate that states and localities carry out certain actions with regard to immigration enforcement? They have to ask or abide by detainers or whatnot. And of course, this is because in addition to federal supremacy clause and preemption, there's also the pushback with states and localities with regard to anti-commandeering, right? Federalism, state rights, which means that the federal government cannot directly compel, mandate, or commandeer a local official or state official to enforce a federal law or carry out a federal program, right? U.S. versus Prince, that was with regard to whether or not you could force sheriffs to carry out federal firearm background checks. Supreme Court says no. More recently, which is very sort of significant for my state, the Obama administration, Obamacare, right, tried to sort of impose a grant requirement with regard to making sort of states raise the eligibility for Medicaid. And the Supreme Court said that that power of the purse was being used too coercively. That's essentially forcing states to carry out a federal program. And as a result, it became discretionary. So my state only very recently voted to expand Medicaid expansion. So why that's important is because despite the fact that we've designed immigration enforcement policy that is entirely reliant on state and local participation, the federal government cannot directly mandate state and local participation. Now, there's a new lawsuit. They want to be able to argue that. We'll see where the anti-commandeering clause actually stands now. I think it's actually a complicated issue, especially because of the fact that it's a conservative doctrine traditionally. But nonetheless, historically, that was the issue, right? Anti-commandeering. So why does that matter with regard to states? Because in some ways, the states became the linchpin in the federal government's enforcement strategy. Why? Because if the federal government cannot force localities to carry out immigration enforcement, the states can. There's some caveats, but for the most part, they can, and they're not restricted by the US Constitution in the same way, because the US Constitution protects states. It does not protect localities from states. So as a result, what's interesting is the tremendous power that the states started wielding in the immigration realm was the fact that the federal government needed the states, in many states, to essentially then either pass anti-sanctuary legislation to prohibit localities from putting up limitations on their cooperation, or more recently, specific mandates, right? Mandates to abide by detainers. Now we're seeing mandates to enter into 287G agreements, something a little further. I call those essentially round one and round two of state responses. Round one being we're just going to get rid of the sanctuary policies and hope local officials will voluntarily participate. Round two being, you know what, we're just going to put specific mandates. SB 1070 did it. We saw it later with Texas SB 4. You got to do the background, you got to do the immigration check. You got to abide by detainers. So there's affirmative conduct that you must do, right? Essentially, we are commandeering you on behalf of the federal government. But what I want to end with is I think we're entering into a round three. And what that round three is not that we want to get rid of the limitations on your officials helping the federal government, or that we're going to make you help the federal government. I think round three is we don't need the federal government at all. Now, we started this again with, strangely named, also SB4, just a different year, in Texas, where, as was noted a little bit earlier, they passed their own immigration law. They defined as a matter of state law unauthorized presence, and then also stated in the state law that they would have some sort of deportation process in which a state court will issue to some sort of law enforcement official the responsibility to see an individual to the border, right? That's enjoined and currently being considered. Texas passes that, Oklahoma copies, Iowa copies, those are all enjoined. But I've been tracking these bills, I have a whole list of them here. But just in the last week, Idaho and Missouri has proposed a similar legislation, right? Proposing their own laws, along with the fact that states like Florida and Tennessee are also putting in real money to create, in some ways, their immigration enforcement force. Sometimes they call it a liaison, sometimes they're calling it that we're just going to do it ourselves, partly following the Texas model and how they use their National Guard, but partly, I think, also just pioneering something new. What I'm seeing with this is actually not necessarily that we're going to follow and essentially assist federal enforcement. It's that we're going to take the lead, and maybe that, you may follow, right? We will do the lead and we will send them to you. Now, why I say is not only is this reversing it, sort of the relationship we normally think between the federal government and the state, why I think it goes beyond just using states to essentially carry out the federal program, but in some ways maybe states prodding and directing the federal government to sort of follow their particular lead, is I think that all this came about and came around for me when I saw the details of the Lake and Riley Act. So you've heard a lot about the Lake and Riley Act in public. You've heard a lot more interesting details here. But what always surprised me about this act is it seems like for an administration that wants a tremendous amount of power, and essentially for this concern that what we really want to do is have more sort of immigration enforcement, that this bill has two strange components to it. The first is that this ties the hand of the federal government. It is a detainer and detention mandate. It says essentially that we already have detention mandates, to be sure, but what it's really adding is for low-level crimes that wouldn't be subject to mandatory detention now, shoplifting, low-level theft offenses. There's other things mentioned, but those would have already been covered by other things in most aspects. That it requires the federal government to first issue a detainer, whether they want to or not, and then to take custody of those particular individuals, right? Interesting enough, out of all the different parties, I feel like ICE actually expressed more concern about this bill than the Democrats did, but we'll get to that in another sort of session. And that's what I said, right? I said that this is going to require a tremendous amount of capability and detention capacity that we do not have without substantial appropriation. In fact, they said that this is perhaps going to overwhelm our capabilities, right? So they were quite concerned about the fact that this would tie their hand. In addition to this, and you might say, okay, that's fine. We have detention requirements. We've had it since 1996. The fact that most presidents haven't abided by the literal sort of terms of the detention mandate is because we've never got enough money appropriated. And essentially, as a result, we've made sort of choices about who to detain and who not. We call that catch and release, at least derogatorily, but that's just a sort of a matter of priority and sort of process. So maybe Lake and Riley becomes that, except for the second part, which is essentially it authorizes states' attorneys general to sue the federal government for, among many other things, including failure to abide by this particular and many other detention requirements. Now, why I say that this is a poison pill? Well, first of all, the fact that a state's attorneys general, I mean, I'm only half jokingly when I say this, is that the Lake and Riley Act is really the Ken Paxton Campaign Immigration Enforcement Act. Like, that's what it is. Like, that's what they're talking about when they say state's attorneys general. They saying it's Ken Paxton. But the second thing is why I think this is a poison pill is this. And again, this is a hot take. So I could be completely wrong on this. I suspect that once all the enthusiasm and everything dies and becomes about money, that the Trump administration is going to find that not only is all the other promises going to be hard to accomplish, but that even abiding by the Lake and Riley Act by itself is going to prove to be very difficult. That there's going to be certain individuals that will probably be released because there's not enough detention capacity in order to carry all these out. I suspect that a lot of local governments are going to be overwhelmed with detainer requests. We have a lot of mandates on detainer requests, but these are going to balloon, not only because of the other things, because of Lake and Riley. Now, normally that'd be fine. That's just what the choices that executives have to make. But because of this suit, I suspect that, I mean, can I be specific? I suspect in 2 years that essentially, as we're gearing up for the 2028 election, that certain individuals at the state level are going to say, you know what? This is an interesting time because if I want to out Trump on immigration and I want to call him out on this, then I can file suit. And Trump's going to be stuck in a very awkward position of saying that on the one hand, I don't have the capability or whatnot to actually carry out all these requirements, and not just the ones on Lake and Riley. The suits apply to everything in the INA. And on the other hand, we have a state that is sort of suing me on my issue. Now, you might say, as some people have told me, oh, that's fantastical. Except as you already heard, it happened already. It happened in the first Trump administration when Texas sued Trump over DACA. And then, of course, DACA gets revoked. Why? One of the reasons given, litigation risk, i.e., Texas is suing us with a coalition of states. So I suspect that in a little bit, and I think maybe Trump might be aware of this, which at least I think this is why he waited, several days to sign it. And only after he announced the Guantanamo 30,000 capacity that he claims that he's going to get. I suspect that this is a poison pill. And I suspect in some ways you're going to see not Trump sort of leading his flock in this immigration enforcement, but more and more people at the state level trying to out Trump, sort of prodding federal immigration policy going forward. And this is to say, I was talking to a reporter literally, sort of an hour before I got onto this panel. And she was noting to me, interestingly enough, that in talking to Georgia and then also to officials in Texas, that she's detecting very different vibe. That the vibe in Georgia is, we can't wait to help Trump. We can't wait to essentially do whatever Trump does. We're following Trump's lead. Whereas you would expect that from Texas, given that essentially Trump is doing what Texas wants. But the vibe that she's getting from officials in Texas, strategists, including some of the people I've talked about, seems to be more of, oh, no, we're in charge. We could have had positions in the administration and we turned it down because we think we could do more here than we could do over there. So I suspect that we're going to see this reversal, that it's going to potentially be a poison pill. And if we get there, it's going to be an entire reconceptualization of how we think about not only the state's role in immigration, but also the federal government's.
Okay, hello. So I'm Ava Ayers. I'm a little hoarse because I spent a lot of time in a parking lot this morning waiting for a tow truck. It's not a great day for it. So I'm going to talk just a little bit from a big picture perspective about how immigration federalism fits into the system of checks and balances that Supreme Court justices are very convinced you all learned about in high school. I'm less sure than they are. But I think that before I do that, I just want to say how grateful I am to Alexis and Sarah and everybody at the Law Review and Lauren for giving me the chance to share this podium with these panelists. Everybody here is a sort of somebody who's personally meant a lot to me with their writing and their scholarship. So I'm really excited to be here. And of course, to be here with you. So, okay, 12 minutes. Oh, really? Already? Come on. I'm going to negotiate. Okay, here's what I want to say. After the decision in Trump versus United States that held the president to have immunity from criminal liability, there's been a lot of, I think it's fair to say, panic about whether the rule of law is still in effect and whether law is still a worthwhile project. And I think what you've heard from all of our panelists today is ways in which the law and the role of actors other than the president is still a project that can make a difference. Can it prevent suffering? Obviously not. Can it prevent harm? Obviously not. But I want to talk about sort of the tools that remain and the senses in which they're meaningful in the immigration context, as well as some others. So, you know, obviously there are non-law checks and balances. We could talk about the media and popular opinion, and I think it's often underestimated the extent to which popular opinion makes a difference in immigration policy on issues like family separation. I think in the first Trump administration, we saw a significant impact from popular opinion. In terms of states and localities, which is what we talk about when we talk about immigration federalism, I think Professor Sue's talk illustrates a lot of ways in which modeling legal approaches is an incredibly important way that states and localities influence the federal government, often for the worse, but sometimes for the better. The issue of benefits, a little bit of jargon that may be helpful to non-specialists. So sometimes in the field of immigration law, we talk about the difference between immigration law and alienage law, which refers to, on the one hand, immigration law is like who can be here and what are the terms on which they can be here and who gets deported and on what terms. Alienage law is everything else that affects non-citizens in the country. So like what public benefits are you eligible for? Can you get a driver's license as a non-citizen? Can you hold a job as a non-citizen in various capacities? And in that area, alienage law, federal and state governments have significant overlap. You've also heard a lot about litigation against the federal government, and obviously that's a very significant area where the states, particularly in the last 15 years, I think a lot of us suspect that we're heading for some kind of a collision with state litigation, that the Supreme Court will at some point intervene to say, you know, there's a point where the federal government just can't make policy anymore because whether you're Democrat or Republican, you're getting sued by the opposite color states. And national injunctions begin to prevent different presidents from having different policies at all. I don't know when that intervention is coming, if it is, but I certainly think that if you want to be involved with federal policy right now and you don't want to be in the federal government, go work for a state attorney general's office, because not only are they actively litigating most major federal policy issues, but there's a weird little incentive created by the fact that most states independently elect their attorneys general, which means that attorney general is a great place to win the hearts of the people in your state and get yourself elected governor. It's almost like a sort of launching pad or being on deck, right? Because most of your job as attorney general is to sue people who are doing things that are bad. That's much easier than running a bureaucracy where inevitably you're going to alienate people, at least easier as a sort of political matter. So states do have all of those. I want to, coming back to something Jennifer Chacon was talking about in her research, sanctuary jurisdictions is a phrase you hear a lot of. It's very little understood, and I don't want to go through everything that it means to be a sanctuary. But I will say one of the things that most folks think a sanctuary means is you say no when ICE asks you, would you hold that person 48 hours past the time they've served their criminal sentence so that we can show up and take them into our custody? That's called a detainer. It's a request, not an order. As Professor Sue was talking about, the federal government doesn't have the power to issue orders to states to hang on to people. And it may be unlawful. If you're, for students who've taken criminal procedure, you know the Fourth Amendment says you have to have probable cause to think someone committed a crime before you can detain them. Immigration being present unlawfully is not a crime, it's a civil violation. So that request from ICE may actually be a request to violate the Fourth Amendment. which is why a lot of conservative jurisdictions were somewhat shocked during the first Trump administration to find themselves on the list of sanctuary jurisdictions. They just didn't want to get sued for doing something unlawful, and so they were saying no to these, would you mind holding a person without cause. Okay, so that's one of the things that sanctuaries do, and it has a significant effect on who's getting deported in the United States, despite federal supremacy over immigration. Right now, ICE has, I believe, about 20,000 employees. There are more than 1.2 million police officers in the United States. So as a law enforcement agency, ICE is tiny. State and local police are huge, which means that the service that state and local police officers do by helping investigate immigration issues, which, by the way, is a charitable donation to the federal government made by state and local taxpayers, because ICE does not reimburse state or local governments for the money that is spent paying officers to respond to detainer requests, or to even help with investigations, as is occasionally the case, right? So all of that force magnifier effect that states and localities have is something that they are free to simply say no to. And there's been great research showing that doing so, adopting those sanctuary policies, significantly diminishes the number of non-citizens who are deported. It's not that easy with the 20,000 person enforcement agency to wander around the country finding non-citizens. There are ways to do it, and raids are important, but raids are more, I think, a way of terrorizing the non-citizen population than they are an effective tool of reducing the 10 to 12 million undocumented people who are present in the United States. It's not making a statistical impact, it's making an impact on the quality of life for those who are concerned about their status. And I think that's what, there's a great book by Angela Garcia called Legal Passing that documents the difference. She did, as Professor Chacon did, lots of great interviews with folks in Escondido and Santa Ana, which are a sanctuary jurisdiction and a non-sanctuary jurisdiction in Southern California. And so, you know, what happens when you become a sanctuary city, or you go the other way and become a sort of enforcement municipality, whatever the opposite of a sanctuary is, you don't affect the number of people who self-deport, right? This is supposed to be the rationale for harsh immigration policies. It's that, well, people will stop coming to this country unlawfully, or they will sort of go back to their countries of origin. What Garcia's research and other people's research shows is that theory doesn't work. You don't leave your country of origin unless you have a really good reason. And so when things get scary in the United States as they are right now, you don't tend to see people leaving the places they've settled in. Those have become home, right? And they stay. They just suffer more, right? More anxiety, more stress on their children, more difficulty obtaining services, right? So life gets worse. But you do, as a sanctuary, have the power to significantly lift that anxiety and to make life better for the non-citizens. So there are, so as a check and balance, sanctuary is effective, although certainly not effective in preventing deportations, right? That's the one thing that, by ICE themselves, right? It's something that really isn't possible. The other two things I wanted to say about states and localities tools. I'm working on an article on citizenship and the meaning of citizenship. And I think it's important to understand, I hate the phrase culture war. I really don't like it. I'm a trans person, and often when people say trans rights is a culture war issue, they mean it's something that like happens on TV and isn't meaningful. But there is a such thing as conflicts within culture about the meaning of people and the meaning of status and the meaning of citizenship. And I think it's important to understand, as Professor Varsani's research was showing, you know, the issue entrepreneurs as policy drivers reflects the reality that these are not solutions to social problems, right? These pieces of legislation that come up, these crackdowns on non-citizens, in the same way that crackdowns on trans kids in sports are often voted on by exponentially more legislators than the number of trans kids who are in sports. Right? We're not solving social problems, we are achieving political goals, and we're changing narratives. And so with anti-immigration legislation, often a state or local government will have the power to push back against narratives about the meaning of citizenship, the meaning of undocumented presence, and who is and isn't a member of our community. During just for example, in New York City, we've heard a lot of discussion in the last few years about a migrant crisis, right? The phrase migrant crisis, when Texas and Florida started shipping non-citizens to to northern cities, many elected officials responded by talking about something called a migrant crisis, reinforcing a narrative that non-citizens are sort of deducting from a zero-sum distribution of public policy goods. You can't negotiate with a narrative. You can't compromise with the narrative. Either non-citizens who are here are part of our communities, deserving of concern in their own right, or they're a commodity that values or devalues your state tax contributions. To compromise with a narrative by saying, well, we'll vote for the Lake and Riley Act because that'll show us reasonable on immigration, suggests that immigration is discussed in a reasonable way that I don't think it typically is. And I think to understand the politics of immigration, and I'm not a political consultant, although these days it seems you don't need any qualifications for that, at least judging from TV. But I don't consider it my expertise. But I will say that in other areas like trans rights, DEI, and reproductive rights, I think you can see some similar narratives playing out, which is certain people are problems that the government is not responsible for solving or taking care of. And rights, as such, are not a good filter for dealing with those problems. When Justice Alito wrote the majority opinion in the Dobbs case that overturns Roe v. Wade and the right to abortion, his narrative is abortion is a morally contested issue, and therefore the courts shouldn't get involved. But of course, all rights exist because of morally contested issues. Right? Trans rights exist because people dispute whether I, as a trans person, should be treated in a certain way. Immigrants' rights exist because non-citizens are treated in a certain way by people who have moral views about how to treat them. Right? And so when you take the narratives about immigrants being a burden or being a sort of negative commodity, combine them with the idea that rights are something courts really shouldn't be enforcing, you have a threat to the rule of law that goes well beyond immigration law and immigration federalism, and I think needs to be understood and addressed that way, right? That we as a society make rules that benefit everybody, or we don't. And I have a lot more I can say, but I'm out of time. Let me just leave you with one last thought, if I could. I think the other major issue that all of this connects to is police reform and understanding that the role of non-citizens in the United States, as I said, is substantially affected by the practices of local police agencies. As I'm sure you know, almost every police agency in the United States, statistically speaking, is a local government-run outfit, which means that the post-George Floyd movement for police reform, which in my view did not achieve or did not result in radical change in American policing, leaves us in a position where line agents of police institutions, police officers, have significant power over the rights of non-citizens. And if I had one piece of advice to give to government officials who are thinking about sanctuary policies, it would be think about accountability for violating those policies. Think about the extent to which a police officer who decides on their own to call ICE. Of course, you can't catch everyone who violates any police policy. That's one of the whole reasons we have all these conversations. But are these policies that local governments intend to stand behind by taking them seriously as a disciplinary matter within policing, by responding to threats from the federal government to take away funding? Right, many local police agencies receive funding from the federal government in significant ways, or threats from the federal government to litigate. Can be really scary if you're a town government with 10 staff and one part-time lawyer and you hear that there's a risk the federal government might want to sue you. But I think in the coming years of the Trump administration, it's those decisions, which are often made behind the scenes, that are going to make an immense difference in people's lives, as well as the broader decisions that we all make about how we talk about non-citizens and their place in our community. So thank you so much.
So we're going to have time for a few questions and discussion. And if any of our panelists want to jump in with questions for each other, I was just like constantly writing down things throughout that conversation that I want to talk to you all about. But please do jump in. I want to kick us off with one question that I've been thinking a lot about in terms of conflicts, but conflicts in kind of conceptual theories. So on one hand, we have Texas with its death buoys and circular saws and razor wire policing its borders, one of which is an international border, right? Texas is saying, we want to do that. And I think that some of this, Professor Bassani, ties into your issue entrepreneur narrative. So we have Texas unilaterally enacting its own idea of what federal immigration law should be. We then have, on the other hand, Laken-Riley Act authorizing the state attorneys general to sue to enforce federal immigration law. And those are both kind of from the view of the current administration, broadly speaking, like that is in some ways good. And I say that because of the DOJ's positions with regard to the Texas lawsuits have adjusted since the change in administration. On the other hand, we have a detainer request that is a non-enforcement mechanism that is almost state inaction. It is a state saying, I'm going to actually respect the Fourth Amendment and not hold somebody without cause. And that under this current view is a threat. That is something that is sufficiently important and sufficiently severe enough to be state action that constitutes a violation of this kind of federalism system. I'm wondering what your thoughts are on that kind of tension between state positive action for Texas and the authorization through the Laken-Riley Act for states to act and sue, and an almost inaction through the detainer policies. Anybody want to think about that? I'm wondering if there's, sorry, go ahead.
I'll jump in real quick. It's kind of interesting because I don't feel like it wasn't that long ago, and it might have been even a panel I had way back in the days with Michael Wishney, when I was like, you know, in the beginning we were debating whether or not states and localities, and that's your detainer question, that's your Fourth Amendment question, can even enforce federal immigration law. And now we're trying to determine whether they can say no. So I don't think the legal issues are resolved, right? We still have, at least last I checked, a sort of pseudo circuit split. I mean, last I checked, right, in New York, Suffolk County is facing a $60 million judgment for following ICE detainers, right? New York City just paid, I think, a $92 million settlement for abiding by detainers in like 2012 or something like that, right? So there's plenty of courts still and circuits, you know, second and third, more specifically, that have said that abiding by detainers on administrative warrants without separate probable cause that you can establish yourself may be a Fourth Amendment violation on your own. On the other hand, we have the Fifth Circuit, to be fair, in a different context, in Nelson Izzo, that essentially said, oh, well, this immigration detainer mandate, that's okay. Does it raise a Fourth Amendment issue? Well, it's as applied right now, but we think that there's collective knowledge between the federal government and the detainer passes down to local officials. You know, we'll see how that sort of plays out. But it's interesting to note that legally, I feel like this issue is not at all settled. The tension that we're talking about between federal and state are still very much alive. But what strikes me is politically how much that is just out the window, right? And this goes a little bit to, I think, what Ava was talking about a little, you know, as well, is that we are in a world in which this sort of political framework also, and to be fair, some of it is performativity, even what Texas is doing, isn't really actually connected either to a legal framework necessarily, and maybe law doesn't matter anymore, or on the other hand, even connected to I don't know, an efficiency or administrative framework, right? Like, how much is Texas's actions really moving the needle? How much was Trump's bluster during his first administration really moving the needle? Whereas better or for worse, it was, the sort of efficiency, the silent efficiency, if you will, of the Obama administration. Not doing raids, but doing these sort of paper, all these other things that actually led to more numbers. So I do feel like there is a disconnect between, I think, what we're trying to do as a policy and what we're talking about in terms of framing as a matter of politics. And I think that goes into that sort of the tension I think you identify is not at all resolved. But in some ways, the effort to resolve it seems kind of besides the point. And I think that's kind of where some of my concern is coming from.
If I can just add to that, I think one thing that I think it kind of we can pinpoint to the post 9/11 moment is shifts in both the national narrative and in the self-perception of state and local law enforcement about what their own roles are in immigration enforcement that I think we should take account of. So I grew up in Texas in the 70s and 80s in new police officers. They very strongly felt immigration enforcement was not their job. They said, let the INS do it. And these included people who were not particularly pro-immigrant in any way, but there was just a sense that there was work that the federal government had and work that state and local police did, and those were not the same thing. And I really think that if in the moment that we're currently in, that conversation has shifted completely in many jurisdictions. So so in places like California, it's a real push and pull between certain agencies and state electeds about what the limits of their ability to participate in immigration enforcement is. And in places like Texas, I think there's sort of been a wholesale shift so that the assumption is that it is the job of state and local actors to be, or state and local police officers to be involved in this project. And so I think we can't really understate how how mirror world this conversation has become as a cultural matter and as an agency matter at the level of state and local police, and particularly in certain localities. And I think that matters to how we think about the sorts of questions that you were asking.
Maybe I can jump in as well. I think that I very much agree with Rick that a lot of these issues are still unresolved in the courts and at the policymaking level. And in a way, ironically, I think some of the moves in the last couple of weeks actually expand the space for state and local policymaking and for more conflict here. For instance, I mentioned the mass influx invocation. No president had ever invoked the mass influx provision to unleash state and local immigration activities. Now that's happened. We've kind of come to the other side of that. I don't rule out that the next Democratic president will say, there's a mass influx. State and locals, we really need help processing employment authorization documents. We're way behind. So can you start doing the work of USCIS for us if you want in your jurisdiction for your residents? And Texas can say, no, we're not putting our people to review and approve work authorization applications, but New York will do it. And we'll have a lot more work authorized people in the labor markets in New York. Just to say that the mass influx thing actually is much broader than 287G in the powers it can delegate. And now Trump has crossed the Rubicon. Democrats are going to have that open to them, which will open up even broader state and local space. And that's not why they did it. And we'll still need to have another Democratic president. We'll have to need another president at all, I guess. But I actually think that these things, kind of like Rick's point on Lake and Riley, may have longer term consequences than people are focusing on. I wanted to make one other point about law enforcement and detainers. We've been involved, my students and I have been involved in a fair amount of litigation over detainers. I've also spoken to a lot of law enforcement, as others have. And I think that it is the case that many in law enforcement are frustrated when they're pulled away from what they perceive to be their core job, which tends to be violent crime and maybe large-scale drug trafficking or property crimes. And immigration, family law, sort of protective orders, all these things that they think of as social work or something else does pull them away. And because Texas keeps coming up, I want to share a conversation I had interviewing the chief of police in Houston, maybe 15 years ago now. And I was asking him about detainers, and I sort of was asking, like, how big a deal is it really? I mean, so you hold a few people a little bit longer, or in the databases, you have a few more traffic stops where you encounter someone who's got a detainer and you pick them up. Like, I get that it's a little bit of a diversion of resources, but is it really that big a deal? And he like almost pounded the table. He said, you don't appreciate, first of all, police departments, urban police departments, we're always under-resourced, we're always short-staffed, we're always straining to accomplish our core mission. And then he told me this whole story. He said, imagine one of my officers pulls a car over at 2 a.m. and they run some database checks, and there's a hit on a detainer for a civil immigration violation. Well, they don't know on the screen of their laptop in their car, it just flashes, Homeland Security wanted. He said they are trained to unholster their weapon, flatten against the car, approach, assuming this is a dangerous fugitive, fleeing felony convictions, put handcuffs on, bring that person back to the station and sort it out later. And he said, typically I need to give them 1 or 2 days leave because they have alerted, they have gone on alert in a very serious way from their training. And I'll lose that officer for a day or two as they just settle down. And all of that is because some joker at, this was his language, some joker at ICE loads a civil document that doesn't even belong in these databases. And I've lost my officer for 2 or 3 days while he settles down from what he thought at 2 a.m. was a potentially life-threatening encounter. And I was like, okay, I get why you care about detainers now. That does seem more consequential to me. I'm not saying that's the uniform view, of course. There's a diversity of views, but I think law enforcement themselves have a variety of views, as do the National Guard. We keep talking about Operation Lone Star. My students and I heard from a number of soldiers down on the border. They would Zoom from the border, standing on the border saying, what am I doing here? I have important work to do. This is not it. And I'm standing here in a bunch of bushes, staring out at the horizon. This is a waste of my time. Now, that's not the monolithic view of the Texas National Guard. But there were a surprising number of people who were very frustrated at the sort of diversion. And so that policy debate, I think, is alive, even in spaces that seem very closed down.
I'll just say something very quickly, which is Professor Sue mentioned the needle. And I think I just want to echo what you just said, which is, what is the needle? Is the needle actually enforcing immigration, or is the needle these political goals that various people who are passing the policies really have? So you can see why the frustrations of law enforcement, they're saying, why am I sitting here on the border? Because they're not actually there to enforce immigration, right? I mean, sure, they are at some level, they're doing that, but they're doing different work. It's not immigration work, it's political work. And that must be very frustrating, as you mentioned. Yeah.
Yeah. I just wanted to add something really quickly about what Professor Chacon was saying about the mirror world that we live in, because I think it is absolutely fascinating how, like, I graduated law school in 2005, and I remember in various conversations, some people talking about whether there were fair weather Federalists, meaning it used to be, right, a point of criticism that, well, if you're on the right, you're supposed to believe in states' rights and independent state authority and keen separations often that involves between state and federal functions. So, so in some ways, the police chief that Professor Wishney is talking about is an ideal Federalist, like someone with a very clear sense of what's my job and what's the federal government's job. And it feels to me like we're starting to enter broadly a political moment that's similar to, like, I've read a lot about the history of legislation in the 60s and 70s, and I still can't figure out what the Democrats and Republicans were back then. My dad, who by the way is here, and I love him, my dad worked for Governor Rockefeller, who was a Republican working for civil rights, and some weird stuff happened, right, like in there, and the parties all changed, clearly driven by things other than just the identity of the party. It feels like we're starting to see immigration as one of the issues that drives party realignment. I believe there's even some social science research on this, that immigrant feelings drive party alignment, at least party motion to the right in certain ways. And, as somebody who teaches courses involving constitutional law, I've always found it a little bit baffling that people have strong views on whether states or the federal government should be empowered in our system. I'm a proud fair weather federalist. I think we should prioritize whatever is going to do the best job to promote human rights and people's well-being. But I think that view is increasingly, oh, thank you, yay. Another fair weather federalist in the audience. But I think on immigration, we're seeing a lack of what used to be thought as party principles, and increasingly political narratives that are separate from those, which no doubt reveal hypocrisy on the part of some, but I'm less concerned with hypocrisy than I am with well-being and where on earth we go from here.
Where do we go from here? We have a few minutes. We just have a few minutes before we wrap up and have a couple audience questions. I have so many questions about detainers because that's where my head has been at. One of the things I was thinking about when you were talking about the National Guard is this idea of who is enforcing what and what their training is. So for 287G agreements, they're supposed to at least go through some sort of training if it is a 287G agreement that is going to require local law enforcement to actually be enforcing federal civil immigration law. To what extent is that something that is even being worried about today? Not just the training, but the specificity at which we want to be thinking of who is doing, and I think that this goes back to the other questions because we all come back into the same set of questions on these issues, but who is doing the enforcing, what they are doing, what they are actually enforcing, and then how they are doing it and how they know what to do. Do you have any thoughts about that?
Sure. No one unmuted themselves, so I'll jump in. Like Ava, I think I care most about what people are doing. And some things are more likely to promote human welfare and thriving than others, in my view. But I do think the manner matters a lot. And to me, that's less of an issue with detainers and more with the Guard and military forces. I do very much endorse the view that's been expressed that a detainer is just I tell my students it's a postcard from ICE saying, thinking of you. And telling the police, we're thinking about Mike Wishney, and here's a postcard, but it has no more legal effect than expressing an interest by one agency in some person. But on the manner, the last part of your question, I've talked to people who had military careers and are going into this current administration who have said, soldiers are trained to, they just have an on-off switch, and they're trained with machine guns. And when they sense a threat, you start pulling the trigger. And even a fairly rapid recalibration in a few seconds at 20 bullets a second, you're going to discharge a lot of bullets. And putting soldiers on the streets, which is part of where Trump is going, who have no experience of residential law enforcement, worksite law enforcement, the kinds of places where they encounter people who are literally trained to do something very different if they sense a threat or they're uncertain about their environment, is potentially a terrible idea. And so I don't personally want anyone doing worksite raids and residential raids and so forth, but if we're going to have them, I think it matters a lot that it be people trained in law enforcement and not people who lack that training. The stakes are pretty high, actually.
Maybe I'll jump in at this point. Okay, it's good. Okay, it's hard for me to see. To sort of piggyback off that as well, I do think that there are some concerns and they oftentimes are raised by law enforcement. I think we're hearing a little bit, actually, the law enforcement perspective is quite nuanced, but especially with regard to training. But I want to say that actually the issue is a little bit even more complicated than the way you present. Certainly there is training with regard to, all right, people get flagged, what should we do? But that gets sort of elevated because also there are legal requirements, at least with regard to some circuits, that they have to develop probable cause, which also may be evidence that suggests the lack of probable cause. So not only, even if they have a detainer, they might have some obligation to say, is there anything else? And in fact, sometimes state law requires you to do that to determine whether or not this individual actually is not an unauthorized immigrant or something else. This is also along with the fact that we're in a time right now where it really seems like the line between legal and illegal isn't even legal, right? What do I mean by this? I mean, so I don't even remember during the campaign when I think individuals pointed out with all the attacks on the Haitian immigrants in Springfield that they're not actually illegal. They're here under temporary protected status. I think maybe this was to Vance. I don't remember. But I think the statement back was, well, they're illegal in my book. So now we have actually, it's not even about legal or illegal. It's about legal in my book or illegal in my book. And then you add on to the fact, including this was actually some of the complaints by law enforcement officials when Texas passed their SB4, which is now we got to determine whether someone is illegal under state law, which half piggybacks off of federal law, but doesn't entirely because it doesn't recognize asylum and all those other things. So this is just to say that law enforcement have been saying, not only is this not my job for resources, but we do not know how to do this. And quite frankly, I'm not even sure that federal law enforcement officials are always that good at doing this. This is also to show that when we're talking about how this affects immigrants, it's not just immigrants, right? When we talk about constitutional rights, we talk about Miranda rights. It's not about Miranda, it's about the rest of us, right, who would be implicated with this. I always like to joke, and I actually joke all the time. I was like, so I'm an immigrant myself. I naturalized when I was in my 3L year in law school. But I was like, the most undocumented population in America is U.S. citizens. Because most of you, all you got is some birth certificate with your footprint on it in a back closet. And that's all you got to prove you're a citizen. There's no federal database of citizens. Whereas I got iris scanned. I got like 10 fingerprints. I got a picture every 2 years since I was 6 years old. Like I'm super documented. But what this suggests is that what we should be also concerned about is as these things become more difficult and more non-trained entities are making these decisions, we're just going to have a lot more false positives. Even if we keep the false positive rate steady and you magnify 300, 400% the number of people with detainee requests, even if you keep it steady, we're going to have 4 more times of people, citizens or whatnot, getting sort of flagged. And I'm out to do another panel on, grants passed with regard to unhoused individuals. And I'm thinking, how is this all intersected? I mean, the number of U.S. citizens that's going to get deported has already been deported. It must be quite high already. So this is all to say that training is important. Now, I will say one thing. I am seeing in some states these bills in which they are trying to provide money for training. Michigan has SB 42 that seems to be saying they're using a little less sticks, a little more carrots maybe because it's Michigan. Where they're kind of providing incentives and money and training programs, and then 15,000 per officer is what they're offering for training programs. So maybe we get better, but immigration law is hard enough for immigration scholars. To think that law enforcement officials on the ground is going to know how to parse all these things, I think again maybe that's not the goal, but I think that's a huge complication.
Yeah,
and if you just got a certificate, birth certificate, that's all you got. Good luck. Sorry.
So I just want to add to that because I think it illustrates the way in which the policing reform conversation and the immigration conversation go together. But it's also, if there's students from my immigration law class here, they can tell you that understanding even what these statuses mean, to Rick's point, is incredibly challenging, right? People talk about, people say incredibly stupid things like they're illegal to me, which and our current White House press secretary was asked, like, what about the distinction between people who've committed crimes and undocumented immigrants? And she said, well, they're all criminals because they all broke our law, which is just a very embarrassing misstatement of law. I think she knows it's not correct on the law, but it illustrates the way in which citizenship and undocumented status are social categories and not just legal categories. But even beyond that, cops on the beat are often able to tell you exactly what the Supreme Court has said about probable cause. What if it's in the trunk? What if it's a minivan, right? What are you allowed to search? There's an incredibly complicated body of law that a lot of cops have in fact mastered. Immigration law is exponentially more complicated than that. It's incredibly difficult. Somebody said, what does it mean to be undocumented, right? When that's an accusation. Many people who go into removal proceedings prevail in establishing that they have a right to remain in the country. And so the case that Professor Wishney is talking about, where somebody reads something that Homeland Security is sending and don't know what to make of it, seems like we should probably think of that as the normal case, and that even an immigration lawyer who had the chance to look at that and talk to the person behind there might find, oh, we actually have to litigate this before we can conclude for sure what somebody's status sort of really is. And so to send a police officer into an interaction where they're expected to make judgments about that is probably a bad move. What I just wanted to highlight is the way that complexity of law also diffuses accountability, right? So when you have the so-called migrant crisis in New York City, whose problem is that, right? Is it the federal government? Is it the governor? Is it the mayor? Is it individual city agencies, right? Everybody gets to point fingers at each other, and it's not realistic to think that the public is going to be able to distinguish which officer is in charge of things. And there's actually a lot of great political science literature that I read just as an amateur, suggesting that the American voter doesn't distinguish very well much of which elected officials responsible for anything. There's good evidence showing that Woodrow Wilson was held responsible for shark attacks off of New Jersey, which really wasn't fair right at the time. But high profile events sure do take on a lot of prevalence. So this idea of like, well, let's give it to the police. Great. It's hard enough to hold police accountable for things that actually are within their training and that the police departments have policies on. To start holding them accountable or responsible in areas like immigration law, where even professors have a hard time getting a hold on it, has a lot of problems.
We have time for a couple of audience questions before we need to wrap up. I don't get to ask more questions? Oh, there.
Hi, so a lot of states have stronger anti-discrimination than the Fed. And I think the federal DOJ is going to be a lot less trustworthy on anti-discrimination cases going forward. It seems like, I don't know how you're going to enforce this, and I think you were alluding to this, that I'm not going to be stopped and asked if I'm a citizen. I'm not going to be challenged on whether I'm an eligible voter. This is clearly going to be anti-Hispanic discrimination on a regular basis. So I'm curious how states may or may not be able to implement their anti-discrimination laws if the Fed is seeing that as counter to their immigration policy.
Great question, hard one.
I'll jump in with a quick thing. I think you've actually identified something that would be quite interesting, right? And I don't say that as in, I mean, I think we could talk about how that might be a challenge, right? And especially, I don't know. It's weird. We're in this weird moment where like anti-DEI means essentially like be racist. Like it's we're like a weird thing, right? But so I don't know if they're gonna say, you know, your anti-discrimination, you know, sort of law that applies to law enforcement somehow is frustrating immigration enforcement. That would even be a bold claim to make, but who knows? They might make it. But I think you've actually identified something that actually might be sort of interesting. I think in the way I'm thinking about it is like a lot of the fight over this immigration enforcement is on yes or no. But there's a possibility to say that we should be looking at how. And I think actually in that realm, with all the discussion of federal supremacy, it might mean the fact that as long as there still are employees and that they are officers exercising the powers of the state or the locality, however delegated, that we have a responsibility in some ways to set those terms. And if it is something neutral and therefore not like, oh, this is not about immigration, this is just about we should not have racial profiling, or that we have, you know, this kind of enforcement mechanism with regard to that. That might be actually a really interesting way for certain states and even localities to, on the one hand, dodge what we've been talking about, the political craziness of anything called immigration, while arguably having a really good effect and possibly reframing it. So I'm not sure it's a challenge. I think actually it strikes me as something actually interesting that I haven't thought about, to be honest. And I think it might actually be promising.
Thank you so much. I really appreciated Professor Sue's point about documentation, and that brings to mind the presentation discussing Florida's invalidation of certain drivers' licenses issued at state levels by other states. We're also seeing some conversation now about federal invalidation of certain federal documents for certain people, or the issuance of inaccurate federal documentation pertaining to people's sex. And I'm expecting that there will be differences in how people's identity and status is reflected between certain states' documentation and federal documentation. And I'm curious how that might impact immigration enforcement when there are competing documents and competing and shifting document validity policies between the federal government and different state governments.
I mean, one effect, and I think Professor Ayers' comments already alluded to this, is you have sort of the intersectionality of vulnerable statuses, where there will be certain people who, by virtue of their citizenship being in question, which is usually a racialized problem, intersects with other kinds of questions around gender categories, and the availability of appropriate documents. And those individuals will be more likely to experience, restrictions on travel, problems with proof when it comes to citizenship claims. And so I think this is why these are not distinct, problems, but they are problems that are very much overlapping and intersectional. And the question really highlights some of the ways that we can expect to see this play out. It doesn't mean that there are no ways to push back on this, but I do think that it is funny to me. Professor Su's comment flags this, that when we talk about people as quote unquote undocumented, Susan Coutinho in much of her work has showed that the undocumented population is one of the most documented populations there is, in the sense that people retain records carefully, really, in the hope of the possibility of lawful status, really retain rigorous records. And in a way that most native born US citizens have never had to, and have not thought about the problem. But again, when we're talking about vulnerable populations, those are populations that do think a lot about documentation and how it intersects with being. And I think this is a moment where those questions will be front and center.
I just want to add something real quick, which is on the driver's license issue. I know your question is coming from Florida, right? With regard to, we're not going to accept driver's license from states that give it to unauthorized immigrants. The issue is already bleeding further than that. So Tennessee's 6001 that was signed, actually it's about to be signed. It's passed by both chambers. Maybe it's signed this morning. I haven't checked. That actually, besides all this, in this immigration talk, is going to create different driver's licenses for citizens and non-citizens, all non-citizens. Legal permanent residents, temporary, whatever. So the concern that essentially we've already kind of bled out of this illegal immigration authorized immigrant to sort of what Professor Ayers talked about earlier with the sort of alienage and are you a citizen or not? That's now going to be, under this sort of enforcement paradigm, the system in Tennessee. And I couldn't find the other, but there's another state that's going to copy it as well. So we might all be carrying different colored cards in the future on the driver's license. So the police know exactly who they're dealing with when they ask you for your license.
Yeah, and if I could just say too that we're talking about sort of a top-down version of what if different jurisdictions have different kinds of laws and so forth. But there's also the experience of immigrants who have different forms of documentation. Or this just reminded me of when my team and I started doing research on policing and immigration in Arizona back in the mid-2000s, and immigrants got very, very savvy about knowing when they saw a police cruiser, was that Sheriff Joe Arpaio's police cruiser, or was that the city police cruiser? Because they needed to know the difference, because Arpaio had policing powers within the city of Phoenix, but so did the police, and then they had to kind of be savvy about that. So I think there's sort of, from the immigrants' perspective as well, this kind of needing to deploy and be careful about what sorts of documents they're using in which sorts of spaces. I think that'll be an issue as well.
I just wanted to add, if I could, yeah, I think documents are clearly a really significant vector of vulnerability, that it's an opportunity for the government to really mess with people and harm them. It's also implicit in what folks have been saying. It's an opportunity for states and localities to have a huge impact for a positive impact on the lives of undocumented people, because the federal government really can't stop you from giving an identification to someone. And so, New York City has a program along those lines. I also wanted to add that I think that the current attack on birthright citizenship in some ways is an effort to impose documentation requirements that I almost wonder about Professor Sue's point about a poison pill in the Lake and Riley Act, whether there's a poison pill aspect. I was thinking about whether birthright citizenship attacks are also a poison pill. I don't think people have fully reckoned with the extent to which getting rid of birthright citizenship would require every American who is likely to be targeted by law enforcement, that is to say, people of color and people in other targeted communities, to have documentation of their parents' citizenship or immigration status. I don't know if anybody's had a parent pass away, as I have, and you go through their papers. Boy, you sure come across a lot of things. I know where my great-great-grandfather got his college degree. I do not have documentation of their citizenship. And I think that the sort of increasing move towards, we're all carrying multiple colored cards. We're all like, what, are we going to walk around with files full of our parents' documentation? This isn't a world that I think that I still remember when people sounded upset about so-called vaccine passports. That was supposed to be a major infringement on our liberty. But now we're supposed to carry our parents' birth certificates, right? So I don't think people have fully thought through where we're headed. I do think that, to come back to the point about intersections, right, that birthright citizenship was not just a good idea for paperwork. It was also a major success of Black lawyers and activists and people before the Civil War who had done a lot to make the concept of birthright citizenship viable in our culture. And so, it's important to understand that these documentation requirements are a pushback against major advances in the ability of Black people to participate fully in our society and our culture. I think the pushback needs to be understood in those terms as well.
I'm told that we have to wrap up. I want to keep talking to you all, but if we can have a big round of applause for our panel.
So I just wanted to thank everybody for joining us here today, our wonderful moderator, our esteemed panelists. I hope, it was a engaging discussion. So this concludes our symposium. If everybody can come join us down in the East Foyer, we'll have a catered reception. So thank you. I would love to take a picture with all the panelists. Yeah, it's fine. Bye, guys. Thank you so much for joining. We really appreciate it. Have a great rest of your day.